Okay, let's see if I could have both council unmute, please. Great, thank you. We'll go on the record now. This is William Devane versus, let's see, we have Roxanne McClintock, Leanna Richards, Lori Briniak, and Craig Sharp. Mr. Devane, are you able to hear me okay?
Yes, sir.
Okay, you're appearing here on your own behalf. You don't have an attorney, is that correct?
Correct, sir.
Okay, thank you. And then if I could have the other attorneys put your appearances on, please.
Good afternoon, Your Honor. This is Erin Harrington, Assistant Attorney General, representing the defendants in this case. Oh, I'm sorry. Mr. Sharp and Ms. Braniak.
Good afternoon, Your Honor. Zachary Jugan appearing on behalf of defendants Richards and McClintock.
Okay, and Ms. Harrington, I see somebody else from the AG's office, Megan Mertens. Do I need to bring her in as well?
Your Honor, she's not filed an appearance. She was just going to observe the hearing if you didn't have an objection or the other parties did not object to it.
Okay. All right, so we're on the record today. The defendants have filed motions for summary disposition under C7 and C8. I've had a chance to review the motions. Mr. Devane, I did get your response. I had a chance to review that as well. So today is the date for oral argument. And so defense counsel, it's your motions. I'll leave it up to which one of you. Are you both making separate arguments today, or is one person arguing on behalf of all defendants?
Separate arguments, Your Honor, and I'll defer to Ms. Harrington to go first if she'd like.
My co-counsel, Rebecca Marcus Nichols, was prepared to argue this motion today. I think she thought the hearing started at 1:45 is what I don't know if maybe there was another notice of hearing that came out. Oh, she said her ID is not working. Mr. Jugan, would you mind going first? And while I see if I can get Ms. Marcus Nichols logged in.
That works. And I guess I should clarify, Your Honor, we are arguing on behalf of our clients. I would imagine the arguments are pretty similar.
Okay, yeah, go ahead. I mean, I've had a chance to read the briefs, so I mean, I kind of know basically what your argument is, I guess. Is there anything that you want to specifically respond to in terms of Mr. Devane's position?
So with the court having been familiar with the briefs, I certainly do not want to restate all of our arguments and the facts here. Did you have an opportunity to review our reply brief, Your Honor?
Yeah, I did. Yeah.
Okay. Well, I think just quickly for purposes of oral argument, our defenses to the gross negligence claim are based on one, qualified governmental immunity. Defendants are employed by Northern Family Intervention Services. That company contracts directly with DHHS to provide in-home parental care. The defendants were acting out, and they were acting in a role as a governmental function. So in that sense, the defendants are entitled to qualified immunity. I know plaintiff has alleged a claim for gross negligence to circumvent the immunity issue. However, based on the allegations, plaintiff fails to properly plead with specificity how defendants, one, how their actions amounted to gross negligence, but two, how those actions were the proximate cause of the injuries that plaintiff alleges. Part of his gross negligence claim is based on a violation that he does not have standing to bring. That statute is for an abused child to bring, not the father of an abused child. So I think that was important to note. For the other claims, Your Honor, again, I don't want to belabor the point. I mean, from the defamation side, plaintiff has failed to specify what exactly, are the alleged defamatory words, what context they were taken in, how they caused the alleged injuries. Moreover, the statements that he has referred to are statements of opinion. So that does not amount to an actionable defamation claim. Your Honor, for the retaliation claim, there's no independent statutory basis that plaintiff has alleged. Without an underlying statutory basis, there's no cause of action for retaliation. With the civil conspiracy, plaintiff fails to plead an additional underlying tort. That goes to the inability to establish a negligence claim, but also the fact that plaintiff has failed to properly plead, the prima facie elements of a civil conspiracy claim. He more or less just states that the four defendants had knowledge of what was going on and worked together to side with the mother. Those allegations failed to meet the pleading standards for a civil conspiracy claim. And then finally, Your Honor, I know that there's not an enumerated cause of action for malicious prosecution, but just to address that, plaintiff is not entitled to treble damages. There's no evidence or allegations that the defendants even initiated a criminal proceeding that resulted in an unfavorable outcome to the plaintiff. So with those points being made, I'm happy to answer any questions. Otherwise, we're happy to rely on our briefs, Your Honor. Thank you.
Yeah, I mean, you kind of touched on it, but I guess, and the other defense counsels feel free to weigh in on this too, but as to the gross negligence claim, I mean, as pled, gross negligence does take it out of immunity. I mean, how can if it's pled as a gross negligence claim, I can't really dismiss it on immunity grounds.
Thank you.
I'm wondering, Mr. Jugan, if you can tell me, I just was curious why that argument was made, and whether you could tell me why, as pled as a gross negligence claim, about why I could dismiss that as on the grounds of immunity.
There's also an aspect of this that the defendants did not owe plaintiff a duty. He takes issue with the fact that the defendants did not report suspected child abuse, but it's clear that defendants did not owe that duty to plaintiff.
No, I don't, and I understand that argument as well, but that doesn't really go to the immunity question.
The immunity, so plaintiff's pleadings don't give rise to a cause for gross negligence. There's no allegations that defendants, acted with complete indifference or reckless disregard or willfulness to cause any foreseeable injuries. There's also the element of proximate cause, which takes us out of gross negligence. For proximate cause, the court should look at, who's the most immediate, I don't want to say bad actor, but the immediate cause of the injuries that plaintiff alleges. In this case, that would be the mother, who he alleges is guilty of neglect and abuse. Defendants were simply doing their job as required, and their actions do not give rise to a gross negligence claim.
Okay, all right, thank you. No other questions. Which defense counsel would like to address your arguments there on behalf of the AG's office?
I will, Your Honor. I apologize for being late. I had connectivity issues.
Okay.
Honestly, our arguments are along the same lines as the other defendants. So I'm not sure how much you would like for me to repeat a lot of the same information, but based on plaintiff's pleadings, most of the allegations he's making are just conclusory. They're not, he fails to plead facts that satisfy every required element of each claim, which is required as part of the pleadings. He also has to plead, specific violative acts that each defendant committed, and he has not done that either in his pleading. So, and along the same lines as brother counsel, if you will, the state defendants have both GTLA immunity under the Governmental Tort Liability Act, and they also have qualified immunity for any federal claims. So even if plaintiff sufficiently pleaded, which he didn't, we believe immunity covers his claims.
All right, okay, thank you. Mr. Devane, is there any argument you would like to make in support of your position today?
Yes, sir. I do believe that I've met the standard required for gross negligence. In my pleadings, what I provided to the court and to them, the transcript clearly states that at one point in time, Leanna Richards was on my side. She was going to testify in my behalf. Once she left, I felt bad because I finally found somebody that was on my side, and seeing all these weird things that CPS is completely ignoring in their investigations. I called her and told her, I'm sorry, I recorded our entire 3-hour interview, but I intend to sue CPS. Because now if somebody else, a professional, has confirmed what I've suspected, that Lori Werbreniak does not do complete investigations. She targets the father while completely ignoring the mother. That was basically confirmed on May 19th, 2026, when her decision, the substantiation against me, was reversed. What I said, what I told to Leanne Richards then was true. Now, in my opinion, gross negligence is free because these are trained professionals, experts. Leanna Richards has a master's degree. DHS, they're trained. They have policies to conduct these investigations. The investigations are supposed to be conducted unbiased, systematically. They're supposed to explore every source of the possible injury. Lori Werbreniak failed to do that. Her boss, Craig Sharp, who was involved in that investigation, he's in the report interviewing during one of the interviews. He is an expert. He should be able to see that the investigation that he reviewed and signed off on was done inappropriately. He didn't. He gave it the check mark that this was done A-OK, and that turned out to be false. Now, it took a year to the day exactly for this to be reversed. May 19th was when the CPS investigation was started. May 19th, that was of 2025. May 19th of 2026 is when it was reversed. Now, I told this to Leanna Richards, that I believe that Lori Werbreniak and DHS is ignoring significant issues surrounding the mother that they know of. We spent 3 hours going over this investigation, and the person that DHS hired, their professional, brought in the concerns that the mother may be committing Munchausen's by proxy, hurting the child and then blaming the father. She was going to testify to this on the record. It's in the recording. She says, yes, I'm going to testify for you. When we went to court and I actually cross-examined her, she admits on the record, everything is fine. Everything was fine until the point in which I told her I was going to sue CPS, using her words. She didn't like that. She had to confer with her boss, Roxanne McClintock, to see if they would back me up on this. It's in our text message communications that I've submitted as evidence. She's confirming, I need to see if we're going to back you up on this. Ultimately, after she contacted her boss, they didn't. They decided to say that I was a safety concern. That information that's in the report was relayed to CPS, who went into court and said that, yes, I was a safety concern, and they wouldn't complete any more services with me due to that reason specifically. That's simply not true. It's a lie. This was admitted on the record, Your Honor. Leanna Richards admitted this completely on the record. He admitted it. Now, in my opinion, these are the things that CPS is well aware of concerning the mother that they are ignoring, that they are required to consider when conducting these investigations or extended services. The mother has a history of passing out and losing track of time. The daughter involved in the situation has expressed to DHS that she is afraid of the mother and does not feel safe around her. That was not investigated. Lori Werbreniak said that she would have investigated it when she testified, but ultimately it was never investigated, and then It was never investigated by a lawyer, from my understanding. If she goes into court and says, hey, this is something that should have been investigated, it should have been investigated. Now, none of this could happen without each one of them sticking to the story that I'm a safety concern. I went to the court and expressed my concerns to the lower judge, Honorable Burmeister. He didn't change anything with our custody order because he knows me. I've dealt with him for years. He asked at one point, DHS, do you feel that the mother needs a mental health care evaluation? DHS, I believe specifically, I'm not sure about this, Craig Sharp declined. Now the court came back to me, and the court obviously still felt that there was concerns that needed to be looked into, because ultimately I did a mental evaluation with Dr. Edward Cook, very experienced doctor. That evaluation was very favorable to me. After I submitted that evaluation to the court, Honorable Burmeister ordered the mother, Tara Schrader, to get an evaluation done. This is on top of years ago, Honorable Burmeister saw signs that something weird was going on, and he requested her full medical records to be brought in. But during that time, this is one of the things that CPS knows about. That was derailed due to a setup that the mother was involved of. She's deceptive. She lies. Honorable Burmeister has stated this on the record. It's in the transcripts I provided to the court. She used his public services against me. Now, this is something that Honorable Burmeister had to directly tell Lori Werbriniak in court. You do know that the mother does these things, correct? Based establish this, and that she should be concerned when she does these evaluations. Another time is when Lori Werbriniak was involved in a PPO that was put against me by the mother. During that PPO, Lori Werbriniak tried to say that I coached the daughter to what she was saying, that she was being abused by the mother. I would love for the court or anybody to look at this video and you tell me if this child has been coached in any way, shape, or form. These are her natural words. She is freely speaking. The child did reach out to school, and the school told her on the video, between you and your mother, child's exact word. It was heartbreaking for me. Now, an additional, the biggest concerning thing is after Leanne Richards came into the situation and expressed that maybe how the mother is possibly passing out, hurting the kids, and may not even remember it, that is concerning. That is beyond concerning. And in fact, in the DHS policy, it's called an immediate risk factor. It's something that DHS has been ignoring in their investigations, because if they do articulate that in their reports, it goes negatively against the mother. So they don't even bring it up. They only focus on the father, just like I suspected years ago. Now, after Leanna Richards brought this concerns of Munchausen's up, I was like, that's crazy, because my son's been taken to the hospital a lot of times. Right now, he's 7. Up until the point he was 6 years old, I had to fight and dig and get my son's medical records. Your Honor, my son has been taken to the hospital, Munson, in town. By the time he was 6, 115 times, and there's 1 year missing because Munson can't find that year. As soon as that information was realized, everybody involved should have taken action. No reasonable person on the face of this earth will look at a situation where a child has been taken to the hospital 115 times. That is no nonsense. That is real. And say, hey, we might need to look into this. They don't care because it would hurt the mother. Now, when the hospital found this out, they were concerned. So concerned that Carmen Fox, the records keeper, she's 59, probably 60 now. Being perfect, she said, I've never seen anything like this. It was so many, it's 2,100 pages my son's medical records are. I've provided them in a digital copy. It's 2,100 pages, sir. It was so much that it almost lagged her computer out where she couldn't load all the information. So between me, Carmen Fox, and the receptionist, we made an appointment for me to talk to the child's primary care provider, Alexis Stevens. Now, during that point, to show you how severe this is, Your Honor, I am not the primary custodial parent. The mother is. The mother's phone number is on the alert system for Munson, so every time she gets an appointment made, she gets a reminder. Her number out of the notification system, so she would not be notified about that. So I can go into court and say, "Hey, this is what's going on," because if you cancel it, well, I have to tell them at some point, hey, we have to take the son. It's during this day. You have him during that day. He needs to go talk to the doctor. I'm going to be there and talk to the doctor myself also. Your Honor, this is a Friday night. She did everything she could to cancel that appointment. The department manager, Trevor Kirsten, he wasn't sure what to do. So they called their legal team on Friday and spent Friday to Monday morning trying to figure out what was going on. Trevor Kirsten called me back. I have that call recorded. It's in evidence. And he pretty much is explaining to me, no, the mother, due to her legal situation, she can cancel the appointment. There's nothing that you or us, we can even do about it. So I started going through with Trevor Kirsten. Hey, sir, so what can I do? What are my options? Because DHS is ignoring all this. What can I do? And Trevor Kirsten starts going down a list of things. I can take my son. I can do these things. And sir, I've already done that. I did call CPS at one point because they said, hey, you can either use an ER doctor because she can't cancel that. She can't control you taking your son to the ER doctor. My son to the ER doctor. Those concerns, they did call CPS, and CPS says, or there's miscommunication, I believe, where there's already an active investigation. No, there's not. The investigation was over. That substantiation was done. There's no more of the child then that they could report, so there was no report made. I'm not a lawyer, sir. I'm sorry that I'm here before you today. But I don't think that there's any person with a shred of common sense that would look at a 6-year-old child that has been taken to the hospital at least 115 times. Mathematically, it's every 2 weeks, at least. And the DHS, specifically Craig Sharp himself, he has the audacity to say she takes him to the hospital too much. So that's exactly the point. That is the number one identifying characteristic that these trained professionals are supposed to look for in medical child abuse cases. Instead of looking into it, they try to defend it. It's disgusting, sir. I'll be frank with you. It's disgusting. Put yourself in my shoes. I had to spend $40,000, give or take, on $15,000, which the lawyer actually refunded me $1,500 because that's how sympathetic he was to my situation after we won. $15,000, $13,500 to have the substantiation reversed. It was reversed, Your Honor. What I said a year ago was true. She did not do a proper investigation. She miscategorized it in the wrong way to hurt my chances at getting my rights restored to my father. And even Honorable Burmeister said this. When all this started, this is what started it all. I wanted to have my rights restored because I wanted to look to see what was going on with my son's medical stuff. This has been on my radar for years. But without my rights restored, I can't make appointments. I can't talk to doctors. I can't do anything. I told Ms. Schrader, hey, I'm going to file my rights next week. Oh, a week later, she says, I hurt our son and all these crazy bruises end up on him. CPS also knows that at one point in time, Ms. Schrader accused me of sexually assaulting her. Her friends, she told her friends her plan, her friends warned me. And I said, hey, can you send me a screenshot of what you guys are talking about? They're like, oh, yeah. And I go up and I confront her on video and I say, what, you're going to do what? And she said, oh, I don't remember. I don't remember. Clearly, she remembered enough to tell her neighbors what the plan was, but once confronted, she doesn't remember. I don't know what else I can do, Your Honor, except for I had to fight the substantiation because I'm a good man. I don't hurt my kid. I don't spank my son, period. I had 2 of my exes come into court and say, Will's amazing. I have good relationships with my exes, Your Honor. Even my wife, even though my wife, my ex-wife, and when CPS investigated her, she was like, oh, he was a poopy husband, but he's a good father. He deserves more time with his son. So what's happening is that it seems like DHS is constantly creating this narrative where I'm some horrible person. I'm coaching the child without any kind of evidence. I'm a safety concern. All in a distraction to take any kind of attention away from what the mother is doing. Your Honor, as soon as the child expressed to CPS that she was afraid of the mother, she does not feel safe around the mother. Something should have been done, in my opinion. I'm not saying they have to remove the kids. I'm not saying they have to do so. I understand CPS is a hard job. It is a thankless job, just like police. But in the same regard, police and detectives are called in to do an investigation. They can't ignore obvious evidence in that investigation and pin it on somebody they don't like.
Okay, just a
Do I have to go
question.
into the legal?
Oh, go ahead.
Do I have to go into my legal arguments, or does my brief suffice that I just want, if I need to keep going to make my claim more clear, I will, but I think I have, Your Honor.
All right, I just have a question. What's the current status of the custody situation?
We have our court August 24th this month to have a settlement conference about the evaluation from Dr. Cook.
Yeah, but what's your status right now as the father? I mean, do you
I have nothing. I have weekend visits. I see my son during the school year, Friday to Sunday, every 2 weeks, and during the summer I see my son every week, again Friday to Sunday. But in my additional week, it's Thursday to Friday, Thursday morning to Friday evening.
Do you still have a custody case open in front of Judge Burmeister?
Correct, sir. We go to court on the 24th to go over the evaluation that Honorable Burmeister did order. He flat out ordered her, you need to get an evaluation. And in addition to that, this week ago, bridges across common local evaluators, they wouldn't touch it because they're so closely tied to DHS, just like Leanna Richards is, they get money from them. They could create a conflict of interest based upon what's going on because in my opinion, they could be influenced by, they get paid by them, just like Leanna Richards was. It's already been demonstrated, so they backed out completely. That's fine. Pine Rest, another organization 2 hours away, I paid them $3,200 to do it. They eventually backed out also because it seems like they had unethical contact with DHS behind my back.
Let me stop you for a second because I got some very specific questions that I just want answers to, and you're going a little off track of what I'm looking for.
No,
so
I do that. I'm sorry.
In your custody case, I'm assuming you've raised all these issues with Judge Burmeister regarding the Munchausen and all of that. Is that correct?
Your Honor, I have been fighting with Honorable Burmeister for years.
Just Mr. Devane. I just want answers to the questions, okay?
I have.
Have you brought those things up to Judge Burmeister in the context of your custody case?
Yes, sir.
Okay, but he has still had, the mother is still the one with primary custody.
Yes, sir.
Okay, so it's not just that DHS hasn't investigated it, but it hasn't been, nothing's happened on that front in the custody case either.
No, Your Honor, and may I be frank, I have a genuine concern that there is a weird kind of bias happening with the mother where, in my opinion, he has seen everything that I've described to you. The setup with Miranda Bailey Cook, my own former lawyer lied to him in court. I had to hold my own lawyer in contempt of court. There's been numerous things going back and forth with the handling of this case. Now, to some degree, Burmeister has defended me. He has not let me be steamrolled certain things, but in my opinion, he's an educated man. He's smart. He's experienced. I would assume that once he heard on the record that DHS, literally everything was fine and good, but I changed my mind because you told me you're going to sue DHS, that should carry some weight with him, sir.
Okay, all right, thank you. Mr. Jugan, any response argument that you would like to make today?
Just quickly, Your Honor, in response to some of the points the plaintiff made during his argument, the defendants were not required to report suspected child abuse based on a medical condition. Defendants are not doctors. It would be completely outside of their authority and expertise to make a medical diagnosis.
No.
Additionally, Your Honor, this was limited to one meeting with Miss Richards and the plaintiff. The defendants never met with or interacted with the child or the child's mother. And therefore, it would have been completely improper to report suspected child abuse based solely on what the plaintiff was telling. And so with that, none of those actions give rise to a gross negligence claim. So thank you, Your Honor.
Okay, Ms. Marcus Nichols, anything you wanted to add?
Yes, sir. A few things. He said he doesn't spank his son. He admitted to spanking his son. It's in the record. He filed a SIR reply. We haven't really dealt with the SIR reply at all, but he needed to seek leave in order to file a SIR reply, and he didn't. So we just want to note that. He talks a lot about the administrative hearing decision, about his substantiation, but he had his due process in that hearing. You know, it has no bearing on the allegations in his complaint. We've covered the gross negligence. I mean, I think ultimately, like Your Honor has identified, a lot of his allegations surround his displeasure with what's going on in his custody case, but that has nothing to do with his allegations in this complaint. I mean, it's a completely separate case. So, I mean, I think a lot of the remedies he's seeking, a lot of the custody arguments that he's making, it's for the other court, Your Honor. And he's also making historical complaints, which are outside the statute of limitations.
Okay, thank you. Mr. Devane, I'll give you the last word. Was there anything else that you wanted to say?
No, what were the first 2 points that the representative for Star Butler made?
What's that? I'm sorry.
What were the 2 points that the representative for Star Butler made, please? Can you repeat those? I didn't quite hear them.
Defendants are not medical doctors, and they only met with you. They did not meet with the child or the child's mother.
Okay. So to respond to that, nobody is asking for them to diagnose the child or the mother or anybody. Once medical child abuse is something that they, by policy, are supposed to investigate. Munchausen's by proxy would be medical child abuse. The fact that this information, this concern that they made has now been supported by a significant number of hospital visits draws even more support to my claims and the concerns they made about the mother having Munchausen's. Secondly, any professional does not have to interview the mother and can look at the substantial amount of evidence, recordings, testimony, transcripts, everything that I provided and say, there's something weird going on here. That should not be an excuse to weasel out of it, I should say. I don't want to be disrespectful, but that's essentially what's happening here. Now, on the DHS side, yes, no, she is right. This is 2 separate points. I'm not going to drag anything else from the custody case in here, but these are things that they know that have happened that they are supposed to review and consider when doing these evaluations, and they don't do it. And additionally, yes, these things were a direct result of damages happening to me because I had to spend all this money defending myself from this horrible viewpoint or narrative that they're creating about me. I had to pay $15,000 initially, $1,500 reversed back to me, and then another $15,000 for evaluations that DHS should have been doing, but they decline, saying that they don't see anything wrong with the situation. It's absurd.
Okay, all right, thank you. So I did have a chance, as I indicated, to review all the filings of the parties. The attachments, I reviewed carefully the plaintiff's complaint in this case. It is a 4-count complaint. It does allege at count 1 gross negligence, essentially arguing that the defendants had a legal responsibility to conduct an investigation and that it was gross negligence for them to fail to do so. Count for defamation in which the plaintiff argues that the defendants made statements about him indicating that he needed certain services, which he didn't need. A retaliation complaint in that once the plaintiff brought up the refusal to investigate, they then began focusing allegedly on him and his actions more than.
Can I correct that point? I apologize to interrupt.
Sure.
It was the fact that she was on my side, but when I told Leanna Richards that I intended to sue Department of Health and Human Services using her concerns of Munchausen's, that's when the flip happened. That's why it makes it retaliatory. There was no safety concern. It was because I was supposed to sue. I told her I was going to sue, and there is actually a law that covers that. It's MCL 37. It's the Elliott Larson Civil Rights Act. The first statement is that you cannot retaliate due to these circumstances. Find it.
Okay, well, you didn't cite to that in your complaint, and I
Yes,
don't
sir.
think Elliott Larson's would cover what you're alleging here.
Yes, sir.
You have to be a member of a protected class, and that would
Yes.
not include you under these circumstances. But regardless, it wasn't alleged in the complaint, and I'm dealing with what was alleged.
I apologize, yes, sir.
That's fine. And then finally, conspiracy claim, essentially alleging that DHS conspired the 4 defendants amongst themselves to cover up or hide their responsibility and their violation in their failure to report and their failure to comply with their legal responsibility under statute. The defense had moved for summary disposition of these claims based on MCR 2.116C7 under a claim of immunity and MCR 2.116C8. Under number one, I'm not going to really consider the claim for immunity under 2.116C7. I really don't agree with counsel's arguments, and I'm not sure that counsel really addressed my question. I think they kind of danced around it. But as pled, a gross negligence claim, I think effectively gets around an argument for immunity because state actors are not immune, even under qualified immunity, for claims of gross negligence. So the court is going to decide this motion under C8, and under C8 the court has to view the facts in the light most favorable to the non-moving party, in this case the plaintiff. Under C8 the court has to assume that all well-pleaded allegations are true, and in order to grant a motion under C8 the court has to find that even accepting those allegations as true, they still would not establish a basis for the claims pled. Looking first at gross negligence and the elements of gross negligence, I believe the defendants properly cited the case law definition of gross negligence and how that phrase has been interpreted. And it has to be conduct so egregious as to be bordering on intentional conduct. And when I look at the plaintiff's allegations here, and again, in my view and in my reading of it, centers around this idea of, they were brought this information, and so they had a duty to report that information and investigate that information. And I don't find that that rises to the level of gross negligence. In many of these cases, it's up to the individuals involved based on their experience and their knowledge of the case and both sides of the case to make judgment calls and determinations about what should be investigated and what shouldn't. And under the statute, it refers to reasonable cause to suspect. And so that's not in the subjective, from the subjective viewpoint of the plaintiff or anybody else. It's from the viewpoint of a reasonable person. And in order to establish a claim for gross negligence on the pleadings, the plaintiff would have had to plead, conduct over and above just simply what I view as making a judgment call, that whatever information they have didn't rise to the level of reasonable cause. It does appear to me, based on the supporting documentation, that the defendants here did not have any direct contact either with the mother or the child, so they weren't in a position to observe, any kind of injuries or anything directly that would typically give a reasonable cause to a mandatory reporter to either report or initiate an investigation. And the fact that for whatever reason, and at the position that they were in, they didn't find those claims that the plaintiff made to be credible, again, it's a judgment call, but I don't think rises to the level of conduct so egregious that it borders on an intentional refusal to report what any other reasonable person would suspect to be some type of abuse. So the court finds, based on the pleadings, that the claim for gross negligence should be dismissed. Turning next to the claim for defamation. Again, the elements for defamation were currently correctly set forth by the defendants in their brief. One of the most important elements, of course, is that the statement needs to be false or defamatory. And again, that's from the standpoint of either being factually false or defamatory from the standpoint of a reasonable person who is fully apprised of all the facts and circumstances. And the defendants, number one, I think the pleadings are deficient in terms of what's required to plead a claim for defamation. I think there needs to be much more specificity as to which individuals made what particular statements, because the actual language of the statement is incredibly important to a defamation claim. It can't just be general claims that statements were made that were defamatory, because the court would have to look at each individual statement. But aside from that, and I'm willing to accept the fact that the plaintiff is not an attorney and may not be well versed in the specificity required in the pleadings. Again, even assuming that what the plaintiff is alleging is true, in terms of the statements that were made, number one, I don't find that they were false in the sense that they were statements of opinion. Certainly, under certain contexts, even statements of opinion can be considered to be defamatory, but under these circumstances, again, we're talking about judgment calls made by individuals, and in their one or more of the defendant's opinions, after their review of the case, it was their view that the plaintiff was the one who needed some services, and rendering that opinion, even if the plaintiff doesn't like it, and even if it paints the plaintiff in a negative light, it doesn't mean that that's false or defamatory as contemplated under the law. So, professionals are allowed to give opinions about what they think is needed or not needed in these particular cases. And even if they end up to be determined to be wrong after that, it doesn't mean that it's defamatory as contemplated again by defamation law. So the court finds that that count should be dismissed as well. Turning to count 3, the retaliation count, I find that to be, again, from a legal standpoint, deficient in terms of the pleadings. The plaintiff did not cite any statute or any common law basis for a claim for retaliation. So the court finds that that claim cannot stand just on the face of the pleadings. And similarly with the civil conspiracy claim, I agree with the defendant's interpretation of the law that there has to be an underlying tort claim that the defendants conspired to commit. In other words, there has to be, one of the elements of conspiracy is that there was an unlawful purpose, and that unlawful purpose has to be connected to some underlying claim. And there is not one pled as part of the conspiracy count. So the court finds that that count should be dismissed as well under C8. So taken all together, the court finds that the defendant's motion should be granted and that the plaintiff's complaint should be dismissed in its entirety. That would be a final order that resolves all the claims and closes the case. So Mr. Jugan, as the one who's kind of taking the lead here, I'll just ask that you confer with your co-counsel to prepare an order reflecting the ruling of the court today for the reasons stated on the record, and then submit that under the 7-day rule.
Thank you, Your Honor. We'll do. Just to clarify, because I know we will include language that this is the final order that closes the case. Is the dismissal with prejudice then?
Yes. Yeah.
Okay.
Yeah. It necessarily must be, as it's a final order. So
I just wanted to clarify that so that there were no issues going forward. Thank you, Your Honor.
Am I going to have a chance to say anything, Your Honor?
Sure. Go ahead.
I do ask the court to question if the correct standard of law is being applied here. From my understanding, as soon as that investigation was reversed by the administrative court, that removes government immunity. It's not a question about opinions, Your Honor. This is an investigation that was done improperly.
Yeah. I'm not granting the motion on the basis of immunity. I just want to make sure you're clear on that. This is not based on
gross negligence removes immunity.
I know. I agree with you on that.
And the court on the record is affirming that they feel that when a CPS investigator is notified that they, one, admitted that there is a CPS.
Mr. Devane, I'm not going to debate with you. I've issued my ruling. It's a final order, so that triggers your ability to file an appeal. If you would like to do that, these are arguments you can make to an appellate court. I
understand that. That's what I want to confirm, that with prejudice doesn't mean that I can't appeal this.
No, you're absolutely, yes.
Thank you, Your Honor.
Yep. Okay. All right. Thank you. That's all for this hearing. All parties are free to disconnect at this time.
Thank you, Your Honor.
Thank you, Your Honor.
I had it and then it was on the docket still and I had a motion to take it off, so I was confused. I just threw it in the box and I wasn't sure.
I think we're supposed to say.
All right, so now Jen's got it scheduled for 10:08, but it showed up on my docket when they printed this yesterday.
Yeah, because I think I signed it electronically this morning.
Okay.
Yeah.
Good afternoon, Judge.
Hello, how are you?
Good, thanks. Yourself?
Good. I'm bringing the other counsel in here, so just one second. Okay, we've got everybody connected. We'll go on the record in Robinson versus Brazo, file number 2612068. If I could have both counsel put your appearances on, please.
Good afternoon, Paul Davis on behalf of the plaintiff.
Good afternoon, Judge. Mark Mueller on behalf of defendant Brazo.
All right, thank you. We're on the record today for purposes of a scheduling conference in this matter. Mr. Davis, is this auto negligence case?
It is, Your Honor.
Okay. Are there any special aspects to this regarding the liability or damages that would require anything out of the ordinary for scheduling purposes?
The only thing that I could possibly think of would be pre-suit. We attempted to have the vehicle inspected, defendant's vehicle, and unfortunately the insurance adjuster allowed it to be sold. We didn't get it scheduled properly, so there might be a spoliation issue that comes up. But outside of that, I can't think of anything at the moment.
Okay, Mr. Mueller, how much time did you want for discovery?
Our usual is 180 days, Your Honor. This is going to be, liability is disputed in this case. We do have video surveillance of the accident. It's our contention that the plaintiff violated the traffic control device. So it's probably going to be expert intensive.
Okay. Do you have any objection to that 6 months, Mr. Davis, for discovery?
I do not, Your Honor.
Okay. And you guys, normally I don't do, witness list prior to, during the course of discovery, but Mr. Mueller, based on what you said, do you want me to set a deadline for each of you to disclose at least experts or?
I've got no objection if the court wants to. I mean, I'll leave it to brother counsel on whether or not he wants something in writing regarding witness list.
I mean, I imagine we're going to know who each other's using fairly early on. So
Yeah.
Okay, fair enough. Okay, so we'll set a 6 month period for discovery. Mr. Davis, do you have everybody in that you need? Do you need to amend or add any parties at this point?
nope, I just received the underlying declarations page fairly recently, so I won't be adding a UM count or anything like that.
Okay, Mr. Mueller, do you have any non-parties at fault or anything like that?
No, Your Honor.
Okay. And, all right, is there any objection to having mediation within that 6 months for discovery, or do you want to set a different time frame for that? Mr. Davis?
Well, I have no objection. I'll leave it to counsel. I imagine at some point a motion for summary disposition will be coming down the pipeline, and I don't want to waste time mediating necessarily with that hanging out there.
I've got no objection to court-ordered mediation. If the court wants to stagger deadlines in that regard, I've got no objection to that either.
Okay, so let's do this. I'm gonna set a dispositive motion cutoff for 30 days after the close of discovery. And then maybe what I'll just put in here is a mediation deadline to be determined. So obviously you're free to decide to engage in mediation at any point, but if we want to get past that dispositive motion phase before we set an actual cutoff for mediation, maybe that's the best way to go. Tyler, do you have any objection to that?
No, Your Honor.
No objection, Your Honor. If you could, if we could do 45 days after the close, just because in case there's a last minute deposition or something, with the 28-day summary disposition notice, sometimes that gets a little tight.
Any objection, Mr. Davis?
No, Your Honor.
Okay. Okay, I'll write that in. Okay, and then what I'll do is I'll set this for a status conference, either at the close of discovery or the date of a dispositive motion, whichever one is later. And then let's see where we're at that point. Depending on the outcome of any motions, then we can discuss again the mediation and further scheduling from there. Mr. Davis, is there any other dates that I can address for your side?
Not at this time, Your Honor.
Mr. Mueller?
No, thanks, Your Honor.
Okay, so I'll put all of this into an order that'll go out to both of you along with the notice of the date and time of that next status conference. And that's all we have for today. Thank you. You're both free to disconnect.
Thank you,
Thank you
everyone.
both. Have a good day.
Okay, looks like we have both council connected, so we'll go on the record now in the matter of Sherry Powers versus Miller Burke and the estate of Foster Burke. This is file number 2511999. And if I could just have both council put your appearances on, please.
Certainly, Your Honor. This is Brian Zayed on behalf of the plaintiff, Sherry Bowers.
David Carbajal, Your Honor, on behalf of the estate of Foster Berkey only.
All right, thank you. And Mr. Carbajal, this is your motion today for summary disposition under 2.116C10 on behalf of the estate of Foster Burke only. And so I did have a chance to review the motion. I read through the supporting documents that were submitted, the deposition testimony and so forth. Mr. Zaid, I did receive your response as well. And I had a chance to read through what you submitted. So I'm fairly well versed in kind of the factual basis of what happened that resulted in this bicycle injury to Ms. Powers. So with all that being said, though, Mr. Carbajal, was there anything that you wanted to present today by way of oral argument supporting your motion?
Yes, Your Honor. I wanted to emphasize a couple of things, but as a matter of housekeeping first, the strict liability claim is, my understanding is there's no evidence for that. That's not being supported. It is mentioned in the complaint, but it is I don't think there's any dispute that that claim fails on this record. I mean, that's not to suggest that if plaintiff has an epiphany between now and the end of trial that she was in fact bitten, she can tell us, but I don't think that a bite was involved. And I'd like to get that corrected so that depending on how the court rules, I can at the very least dispose of that matter from the complaint.
Mr. Zaid?
Yeah, I don't have any evidence to support the dog bite statute allegation. The remaining claims will be the common law strict based on prior vicious tendencies, if that's established in the record, and only the general negligence claim as well. The only reason it's referenced in my brief response is for the support and indication as to what defines a harborer and a keeper for purposes of the motion. But in terms of the complaint, I can certainly stipulate to remove the dog bite statute allegations because there was no bite.
Okay, thank you. Mr. Carbajal, does that satisfy that part of your request?
It does, Your Honor, and again, I can submit an order to that effect.
Okay, thank you.
Next, Your Honor, the plaintiff has argued against my client, Foster Berkey, a theory under negligence. And I think it's important in this case to note that the plaintiff's complaint against the two defaulted defendant alleges that the defaulted defendants, were the owners. The only allegation against my client in the complaint is that he was negligent and that he owned the property that's located, the house where they were at. I don't think there's, I think the court has to assume that a dog from that house was involved in this attack for the purposes of this motion. And I think it's, on this record, it references a white dog. Again, because the defaulted parties have essentially, there's, I guess, a legal finding that they were the owner of the offending dog, then they were the owner of the offending dog. It was not owned by my client. It was not kept by my client. It was not fed by my client. It was not harbored by my client. It was at my client's home, albeit often, but because of his situation and his disability. On this record, there is no evidence that my client was aware that that dog had any, quote, dangerous propensities or a vicious temperament, or that the dog that was involved had a tendency to run loose. There was a lot of documents that were attached about dogs running loose that belonged to the defaulted co-defendants. There is a couple of references, I think only one with respect to my client that was in 2020 of the dog Hammer running loose. And then there's one in 2017 about Richard Foster, again, the same dog Hammer running loose. And my position on that is, what of it? It's not the offending dog. To suggest that he then also knew that this dog had a tendency to get out, or that would be an issue with respect to the plaintiffs, is frankly not supported by this record. So even if the court were to find that a duty existed, and I submit to the court that I think on the strict liability common law vicious propensities negligence claim, and they would have to first establish that Foster knew that this dog was vicious or dangerous propensities. And quite frankly, Judge, I don't know if a dog running out in the street, hitting the front wheel or crashing into a front wheel of an e-bike constitutes its vicious propensities or being dangerous versus a plain old accident. But anyway, on this record, there's no evidence that my client, Foster, before he passed, would have been charged constructively or otherwise with that notice. And certainly, Judge, if the court finds that a duty does exist for just plain old common law negligence, I mean, what is my client supposed to do when the owners are there? I mean, how is there a breach of what? I mean, he would have to have done something, I would submit, and failed to do it properly, i.e. in restraining the dog, and then failing to do it properly, and the dog gets out, then maybe possibly there's a breach of duty. But on this record, on the facts of this case, Judge, I submit, one, there's no duty. And if the court finds there is one, it wasn't breached. The people that own the dog are there. I mean, what is my client supposed to do?
Thank you. Mr. Zait?
Thank you, Your Honor. I'll keep my response brief and I think mostly to respond to some of the things stated in oral, because I think the briefs were both well done and there's a lot of sufficient information within my response. I'd also like to point out that my response is longer than it usually is, because there is enough here that I think makes this very clearly a motion that should be denied based on there being a question of fact. And the reason that there's a question of fact is because unfortunately for all of us, really, Mr. Burke is not able to testify. I gather we can probably speculate as to how he would testify, and it may be very similar to the things that he's said to some of the witnesses that we've deposed, and that's been detailed in my brief. And it also would be probably similar to the remaining defendants who are defaulted yet appeared for their deposition. There's enough inconsistency in this entire case from the testimony of the defendants that should make this an easy decision, in my opinion. Respectfully, Your Honor, I know it's a decision of the courts, but while there are a lot of inconsistent statements regarding the dogs, I think that leads towards the credibility, and with their credibility issues and the lack of there being a living member of the claim, Mr. Foster Burke, I think this is a decision that a jury should make. I think there is a duty. I think the duty of the landowner in allowing the dog to remain was breached when he did allow these dogs to remain, with the amount of testimony by witnesses and prior reports. And I know that it may not necessarily be of the specific dog, but again, Mr. Keith Miller and Burke refused to acknowledge the involvement of the animal that was there. And when I say that they refused to acknowledge it, I think it's pretty clear in the records that the dog that everyone else saw was there, but they refused to admit that that dog was there in testimony. There is a video that I submitted with my brief, Your Honor. I'm not sure if you were able to review it. There was a link to it. I think the video tells a story that's a little bit more clear for us, which indicates that Keith and Ann were you know, in Mr. Carvajal's words, they were there frequently at the very least. But his presence on the video and his reaction to being called out for inconsistent statements makes it very clear that something's being hidden. And what may be hidden is the control and presence of these animals on the property, where I would like Mr. Burke's estate to remain part of the claim and let a jury decide ultimately if while he may not be the owner of the dogs, he certainly allowed them to remain. And under a general negligence claim, there is responsibilities. There's dog law of 1919 that I've mentioned as well. And if the jury decides that there's enough questions in their testimony and their credibility should be questioned without me being able to depose Mr. Burke himself, I think it's fair to assume that my client's version of the events, that a white dog came out and that there is a possibility that they remained there for long periods of time. There is a responsibility under a general negligence claim that was breached by the estate of Foster Burke. For those reasons, Your Honor, I would ask that this motion be denied and let it go to a jury, or at least let it continue for many other purposes. And I'd also like to ask before I finish, if you were able to review the video, or if you would like for me to play the pertinent portion that I mentioned, that can give us some guidance on that, because that'll be part of the record that a jury will see too, and they can make a determination as to whether or not all of these animals owned by the entire family were there and were allowed to remain, and therefore the responsibility of the property owner should also be responsible for the actions that the dog caused for not being leashed, free to roam, allowed to run out into the roadway, causing an accident that my client suffered some injuries from.
All right, thank you. Mr. Carvalho, it's your motion. I'll give you the last word on this.
Yes, Your Honor. I don't doubt for a minute that there is inconsistencies, but I think that they are not material. I think the court, I have conceded for the purposes of this motion that the white dog that was involved with the plaintiff came from the property and more likely, and was owned by the co-defendant. But I don't even need to concede that, Judge. That's what they pled. They've been defaulted. Those are really judicial facts that are not refutable. They did not allege, and interestingly, plaintiff's counsel did not say that Foster Brook was the owner of the offending dog. He says Foster Brook is the owner of the property again, which is not contested. Your Honor, there's a case, and it's a federal case, Fitzpatrick versus Bridgestone. It's 444 F supplement 3rd 786, and it's a 2020 case. That case, the way I read it, and I kind of read it quickly, I think it stands for the proposition that a landowner who has no ownership or possessory interest in the dog precludes a negligence action. I submit to the court, again, that on this record, if the court were to find there's a duty, there's no evidence that Foster breached it. And the inconsistencies that are mentioned by brother counsel, again, are not material. I would ask the court to grant the motion.
Your Honor, may I briefly respond?
Sure.
There's been testimony from some emergency responders that emergency responders and other witnesses that were deposed in this case, and they've indicated that they saw a white dog with Mr. Burke in the back of his pickup truck. There's also been testimony by these same parties that have indicated that when they appeared at his home because of his health condition, for other reasons, that he would indicate that he doesn't own a dog. That's not my dog. Don't indicate on a report that I own a dog. There's reasons for a jury to make the determination of what Mr. Carvalho just stated regarding possessory interest. And I think that should be the reason why the credibility and the inconsistent statements should allow this to proceed, because of the fact that there are people that say they've seen these dogs there. And while I do also agree, the testimony that I have been able to elicit has indicated that the white dog was owned by his daughter and her fiance. I think that the amount of time spent there caring for him, being at the house, him allowing the dog to remain, and him actually driving around town with a white dog in the pickup truck, that there does remain a possessory interest.
If I may, Your Honor.
Yes, go ahead.
If that were the case, that they really believe, plaintiff really believes that my client was the owner of the offending dog, they would have pled it. They didn't plead it, Judge. it's not in their complaint that Foster Berkey owned the offending dog. And I mean, I'm sure the court has read the complaint. It's pretty short complaint and, yeah, but it's thorough.
It is a notice pleading state, and I got this information after it was filed, and I'm not certain that I needed to file an amended complaint after this information became revealed. I thought a notice complaint was sufficient in the state of Michigan.
Yeah, I guess don't bring the dog in your truck, Judge, because you're going to own it.
Okay. All right. Thank you. So I did have a chance to read through all the supporting documents that the parties provided. I did not see the video. I'm not going to ask to play it though. I wasn't able to access the link, but ultimately I didn't bring that up when I first opened the case here today because frankly, I don't think I didn't need to view it. First of all, I think it's important to remember the standard that the court is applying here to this motion. It's a motion under C10. The court has to view all the facts in a light most favorable to the plaintiff, and the court should only grant a motion under C10 if it can find that no reasonable juror could conclude that one or more of the elements could be met by the evidence. And so, you know, if I'm sitting as a fact finder in this case, ultimately at a trial, it might be one thing, but again, I'm looking at this under a C10 standard. And having reviewed everything, it's my view, I agree with Mr. Said that I do think there are sufficient questions of fact here for this to go to a fact finder. And, you know, it is a different case in the sense that we have Foster Burke, who is deceased and can no longer testify. We have Ms. Powers, the plaintiff, who doesn't really have a memory. So two of the key witnesses really aren't available. And so to some extent, there's a reliance on Mr. Wolf, his view of what happened and some of the other witnesses that were there. But looking at all that testimony together, when it comes to the issue of duty and breach of the duty, I think there is sufficient evidence that a jury should look at this, look at that testimony and make a decision about whether or not within our community, the contacts that Mr. Burke had with these animals, the extent that they were at his property, the specifics of what happened on that particular day, you know, Mr. Burke's physical condition and what he could or couldn't have done to monitor those animals or require Ms. Burke or Mr. Miller to monitor those animals while they were on his property. I think all of those things really are appropriate for a jury determination. There's enough room there for a jury to decide, certainly, that based on all the facts together and the history of those dogs on the property and what happened on the particular day of this incident, that Mr. Burke did have a duty in that by, you know, even by omission, that there was a breach of that duty. In other words, he failed to do something that he should have done in terms of the monitoring of those animals, or that there was a possessory interest, or that the dogs were there often enough that somehow that gives rise to a duty on behalf of Mr. Burke. And I think there's enough question on those particular issues that, again, it's not something that the court should decide looking at the facts in a light most favorable to the plaintiff. This is the kind of case that I view as necessary for a jury to make those determinations within this community of what it considers to be a duty on the part of somebody in Mr. Burke's position with regard to these animals. And that's outside of just, I think, some of the more basic questions as to, you know, which animal, which dog it was, and what, you know, the particulars of the incident itself in terms of what happened with Ms. Powers. So for all those reasons, the court finds that there are sufficient facts, again, under a C10, or sufficient differences for the court to find that a C10 motion would not be appropriately granted. So the court will deny the motion. Mr. Said, if you can prepare an order that reflects the ruling of the court today for the reasons stated on the record.
You got it. Thank you, Your Honor.
Thank you, Your Honor.
Thank you. Both parties are free to disconnect at this time.
Thank you.
Okay, we have everybody connected, so we'll go on the record in People versus Lawrence Akers, file number 143749. The record should reflect Mr. Akers is present today by video along with his attorney, Mr. Thompson, and Ms. Koch. We're on the record today for purposes of a hearing. Mr. Akers has filed a petition to discontinue sex offender registration. Mr. Thompson, have a chance to review that petition. I also received a number of letters along with that in support of Mr. Akers. I had a chance to review those as well. Ms. Koch, did you have a chance to review the petition?
I did.
And do the people take any position on whether or not the court should grant this relief?
I was not the prosecutor when this happened. It looked like statutorily the grounds have met, but we don't have a file in our office, so I don't have any background to add to it. But I think statutorily it looks like the grounds are met.
Okay, are you objecting to the court granting this relief?
I am not.
Okay, in light of that, Mr. Thompson, is there anything further that you wanted to state today?
Your Honor, I would agree the statutory grounds have been met. Mr. Akers has done everything that's been asked of him and required of him. You know, I know the court has made itself familiar through the file with the underlying circumstances of the offense. You know, certainly Mr. Akers takes responsibility for what happened back then, but in terms of, you know, the relative severity of this and what he has demonstrated since then in terms of being, you know, a longstanding productive member of our community. Really some tremendous letters of support in this matter from some real community leaders. I think he does meet the standard contemplated by the statute for an individual who deserves to be delisted. You know, it doesn't change what happened. It doesn't change what, you know, he took responsibility for, but those extra requirements and that extra sort of stigmata that is imposed as part of his punishment, I believe it can be lifted at this point. And so I'd ask the court to consider doing that. Thank you.
All right, thank you. I did review the petition, and as I said, the supporting documentation. I do note that several, you know, well-known and well-respected members of our community here in Grayling did present letters on behalf of Mr. Akers. I also had a chance prior to the hearing to review the file. I believe all the judges here had to disqualify based on Mr. Akers' position from the original case. So I didn't have a lot of knowledge, although I was on the bench at that time. I did review the factual underpinnings. Given the passage of time, given the nature of the underlying offense, given Mr. Akers' current status, as well as the letters that were submitted on his behalf, and then finally the lack of any objection from the prosecutor's office, the court finds that it would be appropriate to grant the petition. And Mr. Thompson, you can submit, did you submit an order along with that?
I hope so. If I didn't, I will send that to Jen today, Your Honor.
Okay, so if you'll send that, the court will sign that once it's presented. Mr. Thompson, is there anything further we need to address today?
Not for today's record, Your Honor. Thank you.
Okay, thank you. That's all for today, and all parties on this file are free to disconnect at this time.
Thank you. Judge, can you hear us okay?
I can, thank you. Looks like we have everybody connected, so we'll go on the record now in Veerling Moore versus Moore, file number 2612097. And Mr. Moore, are you able to hear me okay?
Yep, I can hear you okay.
Okay. Mr. Vernon, you're appearing on behalf of Ms. Veerling Moore, is that correct?
Yes, Your Honor.
Okay, I'm in receipt of a proposed consent judgment of divorce. Mr. Vernon, is that how you wanted to proceed today?
Yes.
Mr. Moore, did you want to go forward today as well?
Yes, Your Honor.
Okay, so I'm going to have both parties raise your right hands, please. You both solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Thank you. You can both lower your hands. I'm not sure if that came through. Mr. Vernon, as you're questioning Ms. Veerling Moore, I'm going to ask you to have her speak up because her voice is coming through pretty faintly. So Mr. Vernon, please proceed.
Thank you. Caitlin, did you marry Ezekiel Daniel Moore in the city of Grayling, Crawford County in the state of Michigan on June 4th of 2022?
Yes,
And was that done by a person who was authorized to solemnize marriages?
yes,
And did you have a chance to review the complaint for divorce that we filed in this matter?
yes,
And did you sign that complaint?
yes,
And when you signed it, had you been a resident of the state of Michigan for at least 180 days?
yes,
And had you been a resident of the county of Crawford for at least 10 days prior to signing that?
yes,
And when you signed it, was everything in it true?
yes,
Does it remain true today?
yes,
Were any children born of the marriage?
no,
Are you currently pregnant? Has there been a breakdown of the marital relationship such that the bonds of matrimony have been destroyed and there remains no reasonable likelihood the marriage could be preserved? Is there any chance of reconciliation?
Mr. Vernon, I'm not getting any audible answers from Ms. Veerling Moore, starting with the question about whether she's pregnant.
Okay. We'll
Maybe,
go back.
and you might need to just pause a minute and, because your voice might be, the microphone might not be adjusting to her.
okay.
Just speak up. Can you? So ask the judge if he can hear you.
Can you hear me?
Yes, that's better.
Okay,
That's the tone we need.
okay,
All right. So I'm going to back up. Were there any minor children born of the marriage?
no,
Are you currently pregnant?
no,
Has there been a breakdown of the marital relationship such that the bonds of matrimony have been destroyed and that there remains no reasonable likelihood that the marriage could be preserved?
yes,
Is there any chance of reconciliation?
no,
Did you have a chance to review the property settlement provisions in the proposed judgment of divorce?
yes,
Do you believe that they are fair and equitable?
yes,
You participated in that decision. You were involved in the negotiations with that?
yes,
Okay. Did you have an opportunity to discuss all of those matters with me?
yes,
Okay. And you understand that one of those provisions is that you are waiving spousal support.
yes,
Okay. You understand that by waiving spousal support, you are prohibited from coming back later and asking this court to modify or award some degree of spousal support in the future.
yes,
Okay. Are you satisfied with my representation in this matter?
yes,
You had enough time to discuss all the matters with me?
yes,
And is it still your intention to ask the court to sign this judgment of divorce?
yes,
I believe
All
we're
right,
satisfied.
thank you. Mr. Moore, were you able to hear all the questions that Mr. Vernon asked?
Yes, Your Honor.
Were you able to hear all of her answers?
Yes, Your Honor.
Do you have any reason to believe that any of the answers she gave were untrue?
No, Your Honor.
Okay, and have you read through the consent judgment of divorce?
Yes, Your Honor.
Okay, and I see that you signed that back on July 13th of 2026, is that correct?
That is correct, Your Honor.
And you understand that under this judgment of divorce, you would not be receiving any alimony or spousal support, and that you would be waiving that forever. You would not be able to come back later and ask the court for that.
Yes, Your Honor.
And then by signing this judgment, does that indicate that you're willing to abide by all the terms of the judgment?
Yes, Your Honor.
All right, thank you. Mr. Vernon, did you have any questions for Mr. Moore?
No, Your Honor.
Okay, I've reviewed the consent judgment. I find that it's generally equitable, that it contains all the provisions required by statute. I've heard the testimony of both the parties here today. The court finds that the statutory grounds for divorce have been met. The court will grant the divorce, and I've signed that judgment with today's date. Mr. Vernon, is there anything further from your side?
No, Your Honor, we'll come over and pick those up tomorrow, so you don't have to mail them out.
Okay, thank you. Mr. Moore, did you have any questions for me at all?
No, Your Honor.
Okay, thank you. That's all for this hearing today, and all parties are free to disconnect.
Thank you, Your Honor.
Thank you, Your Honor.
Okay, Ms. Koch, we're on the record now in State of Michigan versus William Thompson, file number 961400. This is Mr. Thompson's application to set aside a conviction. I believe we reset this after a hearing. Maybe it was last month, I can't remember. But Mr. Thompson is not present today. This hearing was set for 3:30. It's now 3:37. I had a chance to just take a look at the statute. In my view, he's asking to have an OUIL third set aside. I don't think under the statute he would be entitled to have that set aside. I'm not sure if you take a position on that.
I reached out to basically the head of all of this for the state of Michigan, and they said that you can't do the seconds or the thirds to set aside.
Right, okay, so we're in agreement on that. So I'm going to I think there was an order in here. If there's not, I'll prepare an order just reflecting that the court is not granting the petition, and then we won't schedule any further hearings, but thank you for appearing on this today.
Thank you.
There's not an order.
Oh, sorry. Oh, good one, Jim. Try to schedule it too. All right, ma'am, are you able to hear me okay?
Yes. Can you hear me?
Okay, I can, thank you. So we'll go on the record now. This is Ferguson versus Ferguson, file number 2612114. The record should reflect that Victoria Ferguson is present by Zoom video today. Ms. Ferguson, I have this set as a date to enter a judgment of divorce in this case. Is that how you wanted to proceed?
Yes.
Okay. Okay. Ms. Ferguson, if you could raise your right hand, please. You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. You can lower your hand. Ms. Ferguson, I'm going to be asking you a series of questions. The questions that I'm going to be asking you are those that I'm required to ask to establish the grounds for divorce under Michigan law. The first question I have, you filed a complaint for divorce in this case and you signed that complaint. Is that true?
Yes.
At the time you signed that complaint, have you been a resident of the state of Michigan for at least 180 days?
Yes.
Had you been a resident of Crawford County for at least 10 days?
Yes.
In the complaint for divorce, there's a statement that indicates that there's been a breakdown of your marriage relationship such that the objects of matrimony have been destroyed and there remained no reasonable likelihood that the marriage could be preserved. Was that true when you filed that complaint?
Yes.
Does that remain true today?
Yes.
Are there any children that were born to or adopted by you during the marriage that are currently under 18?
No.
Are you currently pregnant?
No.
In the judgment of divorce, you would not be receiving any spousal support or alimony. You understand that you would be waiving that forever and that you would not be able to come back later and ask the court for that.
Yes.
Okay. And you and Mr. Ferguson are going to keep whatever property that you have in your possession, and you don't own any real estate or real property together. Is that correct?
Correct.
Are you asking to have your last name changed?
No.
Okay. All right. The court finds that the statutory grounds for divorce have been met by the testimony of Ms. Ferguson. This is a judgment by default. The court notes that Mr. Ferguson was provided with the summons and complaint and properly served, that he did not file an answer or otherwise defend. He was also provided with notice of the date and time of today's hearing, and the record should reflect he did not appear, so the court finds it would be appropriate to enter the judgment of divorce at this time. So Ms. Ferguson, I've signed that judgment. It's effective as of today, so your divorce is final. Do you have any questions at all?
No.
Okay. Thank you. That's all for today, and you're free to disconnect at this time.
Okay. Thank you very much.
So that concludes our